This AI-generated podcast is for general information only and does not constitute financial or legal advice. Please consult a qualified professional. Welcome to the Luxembourg Fundcast. Produced by Bertrand Mariaux, a regulatory lawyer qualified as Avocat à la Cour in Luxembourg and Paris, this show brings you reliable insights on Luxembourg regulations sourced from curated official references. This episode is current as of 24 May 2026.
Thank you. It is great to be here for this deep dive.
Yeah, we have a really fascinating topic today. We are looking at the highly precise, very high-stakes regulatory framework that governs how investment products are marketed in Luxembourg private banking.
Right, and it's a dense one. We're sourcing this from a legal and regulatory briefing titled The Luxembourg Private Banking Marketing and Regulatory Framework.
Exactly. And our mission today is to decode these rules. We want to move past the heavy legalese to understand the core philosophy of investor protection, the strict operational realities, and why this matters on a huge pan-European scale.
I mean, it's a very mechanical system when you break it down. It forces absolute transparency.
It does. And to frame this for you listening, imagine you're trying to sell a high-performance sports car.
Okay.
But the law dictates that for every second you spend talking about its top speed, you must spend equal time and equal emphasis explaining the physical risk of crashing.
Right.
And you can't just put a generic warning sticker on the dashboard. Your pitch actually has to perfectly match the engineer's technical manual. That is essentially what financial marketers face in Luxembourg.
Yeah, that is a great way to think about it. You're basically required to outline the risks of your own product in the exact same breath that you promote it.
Which brings us to the core philosophy here. To understand how these communications are built, we have to look at the foundational rules.
Exactly. The source material explains that marketing materials sit at a very complex three-way intersection.
Three different sets of rules. Right?
Yes. You have conduct of business rules, product disclosure rules, and fund marketing rules, all overlapping.
Wow. Okay, so if I'm drafting a client-facing document, I have to navigate all three of those simultaneously.
You do. And the overarching umbrella for this is MiFID II, the Markets in Financial Instruments Directive II.
Right. MiFID.
But under that directive, all client-facing info must be, quote, fair, clear, and not misleading.
Fair, clear, and not misleading. I mean, that sounds a bit subjective, doesn't it?
Yeah.
If you're a financial firm trying to invite an investment action, how do you actually enforce equal prominence without your marketing brochure just turning into a giant warning label?
That is the exact tension the regulators want. The whole philosophy here is investor protection. They want to ensure the client understands the product, the risks, and the costs long before they make a decision.
Okay, but how does fairness translate to actual compliance on the page?
Well, crucially, marketing has to be clearly identifiable as marketing. You absolutely cannot blur the lines between a promotion, objective advice, disclosure, and actual execution.
So no disguising a sales pitch as neutral financial advice.
Exactly. And the compliance here isn't just about slapping generic disclaimers everywhere. It is documentary and linguistic compliance.
Linguistic compliance.
Yeah. It requires using language the target audience will actually understand. If you use simple language for the benefits, you must use equally accessible language for the risks. They have to be presented with equal prominence.
Oh, so you can't bury the risks in dense jargon at the bottom of the page.
Right. Which leads us to exactly who has to follow these standards.
Let's get into that. The briefing outlines specific players, right?
Yes. These rules apply to Luxembourg credit institutions, investment firms, AIFMs, which are alternative investment fund managers, and UCITS management companies.
What about depositaries?
Depositaries are actually not primary addressees unless they issue or distribute the material themselves. But the most important category mentioned here are sellers of PRIPes.
Right, PRIPes. Packaged retail and insurance-based investment products. And for those products, there is a very specific document involved.
Yes, the KID, the key information document. For PRIPes, the KID is a piece of mandatory pre-contractual information.
And it has to be given in good time before the client is legally bound, correct?
Exactly. The KID allows retail investors to clearly compare risks, internal costs, and future performance across different products.
So, if I use another analogy here, if the marketing material is the flashy movie trailer, the KID is the unedited, behind-the-scenes documentary that you absolutely must watch before buying a ticket.
That's spot on. And the golden rule is that the KID is strictly not marketing material.
Right. It has to remain clearly separate. But why go through the trouble of keeping them so strictly separate if they both just end up in the same retail investor's inbox anyway?
because keeping them separate prevents that blurring we talked about earlier. The KID provides a stable, objective anchor. It represents the contractual offering documents.
Okay.
Marketing, on the other hand, is an invitation to act. And under Article 4 of Regulation, EU 2099 Elm 56, which has been applicable since August 2021, marketing can never contradict the KID.
Or diminish its significance, right?
Exactly. It cannot contradict or diminish the significance of the prospectus, the key investor info, or the Article 23 disclosure for alternative funds.
Which sounds like an incredibly intense operational reality. I mean, think about the practical side of this. With strict rules separating marketing pitches from hard data, how do firms actually execute this in the real world without grinding their operations to a halt?
Well, I have to be meticulous. Every single product sheet, web page, slide deck, or even a relationship manager script must be checked against 3 anchors.
Which are the MiFID II standard, the product disclosure set, and the fund marketing regime.
Precisely. And we aren't just talking about standard administrative charges here. The real operational costs are legal review, compliance, translation, and strict version control.
This sounds like a massive paper trail. I mean, if you are launching a product across multiple countries, isn't translating and version controlling every single slide deck incredibly daunting?
It is complex, yes. But firms frame this not as a burden, but as a critical execution discipline.
Okay, an execution discipline.
Yeah. It is standard operational parameters to preserve the jurisdiction's commercial appeal. They have to ensure the product description, the performance wording, and any sustainability claims perfectly match the binding documents for that specific client category.
And they have to prove they did it, right? Record keeping.
Yes. Under MiFID II, marketing communications must be retained as records, except for oral ones, which we'll get to later.
Ah, right.
Firms must make communications legally traceable before they ever reach the client. They preserve evidence of exactly what was sent, when it was sent, and through which channel.
So it's a completely audited environment, which really zooms us out to the macro view. I mean, why does Luxembourg's adherence to these specific rules matter to the entire European financial ecosystem?
It matters because Luxembourg is strategically relevant. Private banking, fund distribution, and product documentation all meet in the exact same transaction chain right here.
And the briefing backs this up with data from ESMA, the European Securities and Markets Authority. They published a report on January 6, 2026.
Right. And that report proves Luxembourg's dominance in this space.
The numbers are wild. Luxembourg accounts for 59% of outbound fund notifications across the EU.
Yeah, 59%. To give you some context, Ireland is next at 30%.
Wow. And across the EU, the split is 56% UCITES and 44% AIFs.
Exactly.
But I want to stick on that 59% statistic. Over half of all outbound notifications come from one place. If Luxembourg's compliance engine stutters, does the whole European fund market feel it?
Oh, absolutely. That is exactly why these stringent, trace-everything operational rules exist. Because Luxembourg is the primary hub, the integrity of its marketing and disclosure framework literally underpins the trust of the broader European market.
So it's not just local compliance, it's the foundation for cross-border functionality.
Exactly. And just to note, the next fixed statutory ESMA reporting point on this is June 30th, 2027, as per Article 8 of Regulation 2019-1156.
So we'll get another look at those numbers then. Well, let's quickly recap our journey today. We started with the foundational MiFID II rules of fairness, fair, clear, and not misleading.
Right.
Then we looked at the strict separation of the KID, which acts as that objective anchor. Then we went through the rigorous version control reality, and finally how this exact precision sustains Luxembourg's 59% market dominance.
It really is a highly tuned machine.
It is. And for you listening, whether you're analyzing financial products, working in marketing, or just trying to understand global capital, the standard here is clear. Truth in advertising is not a slogan. It is a heavily audited, legally binding paper trail.
It is. But I want to leave the listener with a final thought on that paper trail.
Oh, go ahead.
We mentioned earlier that the rules explicitly state marketing communications must be retained as records.
Right. Except for oral communications.
Exactly. There is an oral exemption. But think about the future. Artificial intelligence, voice notes, casual video calls, these are increasingly dominating client-manager relationships.
Yeah, that's true.
So how long can this oral exemption really last before regulators demand a paper trail for our real-time conversations too?
Wow, that is a provocative thought. A legal paper trail for every spoken client call? Definitely something to explore on your own.
Definitely.
Follow on Apple Podcasts, Spotify, or wherever you get your podcasts. Subscribe to Bertrand Mariaux and Rigor Media on YouTube. Connect with Bertrand on LinkedIn at bertrandmariaux.com. All links in the show notes. This was the Luxembourg Fundcast.